All right, folks, this is Brian Crowell signing on again. This is another video, and I'm going to try to put one video out a week on issues dealing with collective bargaining and public education in California. Um, just in our credential programs, they do teach us pedagogy, differentiating instruction, ways to structure our practice, ways of continuing education, ways to help struggling students. They teach us how to operate in the classroom. However, they do not teach us all the rules, laws related to our practice, which is why that is something that's desperately needed. And so this will be a short video on the Ed Code. The K through 12 Ed Code is something like 64,000 codes from, basically 1 all the way to 64,000. And you'd be surprised, in the scheme of the Ed Code, there's only about 10 codes that are actually there to protect the rights of teachers. Only about 10. You'd be surprised. The rest of the code is absolutely designed to slam you. So we're going to go over some of these codes. And I suggest you, basically, if you watch this video, I would, start in your personal email, hyperlink it, whatever, but you want to keep these handy because I would suggest, pretty much bet one time in your 25 or 30-year career, you will need these codes. And so we'll start with the first one. And this is the beginning in California Ed Code 75, and it's just one sentence. Shall is mandatory and may is permissive. And you'd be thinking, like, well, why does something that says something simple as shall versus may, why is that so important? Well, shall, as it sounds, is mandatory language. It's something the employer must do. Must do. And if the employer does not do that, that gets into arguments of unlawful motivation, deviating from contracts, and actually can serve to give you literally causes of action to defend yourself. So you want, in a collective bargaining agreement, you want shall in your contract. You do not want anything to say may. May is just basically employer may violate your rights as much as they want. So you do want mandatory language in your contract, and there's lots of case law. Thomas versus Driscoll comes to mind. There's lots of case law on shall versus may. So you definitely want shall language in your contract, and you want to use shall if the employer has deviated from it. So that's the first one. Okay. The second code is Ed Code 220. Which is also towards the beginning of the series of the Ed Code. And it simply says, no person shall be subjected to discrimination on the basis of disability, gender, gender identity, gender expression, nationality, race or ethnicity, religion, sexual orientation, or any other characteristic that is contained in the definition of hate crimes set forth in Section 422.55 of the Penal Code, including immigration status, in any program or activity conducted by an educational institution that receives or benefits from state financial resources, or enrolls pupils who receive state student financial aid. So notice it says no person. This code is usually in the context of students, but it says no person. That includes us, public education teachers. So Ed Code 220 is something that you want to be aware of. Now we're going to get into something really, really tricky here, because this gets into corporal punishment, and this is where teachers I talk to run into a lot of trouble. And full disclosure, I am not a lawyer. I cannot give legal advice. I can represent you in the context of a union-related activity. But this is basically just simple, what's called legal education. This is full disclosure. This is not meant to be legal advice. This is just legal education of stuff that you can look up on your own, but it is something that you absolutely need to know. So when you talk California Ed Code 49001A, is very specific. For the purpose of the section of corporal punishment, in quotes, means the willful infliction of or willful causing the infliction of physical pain on a pupil. An amount of force that is reasonable and necessary for a person employed by or engaged in a public school to quell a disturbance threatening physical injury to persons or damage to property for the purpose of self-defense or to obtain possession of weapons or other dangerous objects within the control of the pupil is not and shall not be construed to be corporal punishment within the meaning of the intent of this section. And then it goes on for another sentence. In other words, by law, you can break up a fight. You can break up a fight. However, I would suggest that you do not do that. I can't tell you how many teachers have been accused of corporal punishment and have been fired and lost their jobs for breaking up fights and intervening because they thought that was the right thing to do. And it's like, well, the Ed Code says that I can break up a fight to prevent students from harming each other or others. And then you look at it, it's like, well, that's not how the employer is going to see it most of the time. Most of the time, the employer will assume that you were trying to harm the student. So, you see what I can't tell you. So, I would, if you see a fight, not only can you injure yourself, and then you're looking at a workers' comp issue. If I see a fight, I would strongly represent, do not touch the students. Don't touch the students. Obviously, when you're down there in kindergarten, in elementary levels, that's a little bit different, and little kids like to hug the teachers at those levels. But I would recommend for middle school and definitely high school, do not touch the students. As a matter of fact, and if you're a male teacher, you don't want to be accused of anything. Leave your door open when you are with students. Just leave your door open. You have no idea how dubious the employer can be in this situation. So even though the Ed Code 49001A says you can use force to quell the disturbance, I don't think you should do that. So keep that in mind. You don't want to do that. Let's move on to grades. Now, grades is interesting because this is one of the stronger codes in the Ed Code, 49066 and 49066B, which basically says you may issue the grade that you deem appropriate. It's your jurisdiction. That's your purview. Unless it's fraud or clerical error, the grade you issue is final. If the superintendent or parents want to question your grades, they have to schedule a hearing with the board. It gets really, really messy, and the case law on this issue strongly favors the teacher. So grades is your baby. It has been challenged, obviously. I've got some experience with that myself, but grades in the end are your baby. You can give the grades you see fit. And that's why you are the classroom teacher of record, and that's why you get a credential and you're professional and you know what you're doing. So grades is in your purview. There are some equity issues, but it is the discretion we have as teachers is to issue grades. So that's that. Okay, so that's number 3. Number 4 is in a series. This is the Whistleblower Ed Code for Public Education. I want to thank our brothers and sisters at CSEA Union for getting this into the Ed Code. This is the code, California Ed Code. It's the series 44110 to 44114. This is the code that allows you to blow the whistle on the employer. And basically, this is the code that allows you to tattletale. This is, my employer is doing improper governmental activity, specifically waste, fraud, or abuse, violates a board rule, violates a board process, violates an administrative regulation. I caught the employer doing X, Y, Z. This is what protects you from the employer, because you're not protected in the evaluation process. That you're just a dead duck. There's no protection in the evaluation process, but there is protection when you are purview and witness improper governmental activity. And 44110 to 44114, the Ed Code does have some teeth in law enforcement, and it does give you a level of protection. So that is something that is strong. And I have seen people in, we'll call them state employee venues use them. Kathleen Carroll comes to mind. If you want to look up Kathleen Carroll versus the Commission on Teacher Credentialing, that is a classic whistleblower case. I definitely suggest that you keep that in mind. And it is in a series, as I said, 44110, 44111, 44112, 44113, which describes it at length, and then 44114 is the enforcement part. And those are the codes for whistleblowing. Now, heaven forbid, as an educator, you ever get sick. Sometimes, be it stress, family issues. We hope you remain healthy in your 30-year teaching career. But there are times when teachers get sick. So these are the codes to protect you when you get sick. So 44977 is basically your extended medical leave for a year. So you, by law, can be out for a full school year, depending on if you have your sick leave or if there's a sick bank. But you can be out for a full year and retain your job. That's true. That's under 44977. If after that full year you are still not able to work, then you move to the next code, 44978.1, which is basically unpaid medical leave of absence status. In other words, you are on the 39-month rehire list, but you remain an employee with the right to return when you are healthy to do so. The case on that is Viguez versus Long Beach, specific Bonita Viguez versus Long Beach Unified School District, a famous appellate case of a teacher who, was injured and couldn't come back to work and finally got back, got healthy enough to return to work. So 44978.1 allows, by law, the district must retain your job for 39 months. And this is after the year you were already off, if it was consecutive, which is 44977. So you're talking about up to 51 months you could literally not be at work and still be, quote, attached to the job and employed. Keep that in mind. 44978.1 is very important. Now, I have an asterisk here for this last code, and this is in a series. This is if your faculties, your mental faculties, heaven forbid that happens, that does not happen to you, but if your mental faculties break down and the employer doesn't think you can do the job, you are entitled to a fitness for duty exam under California Ed Code 44942, which is basically a panel of 3 psychiatrists, and they have to determine whether or not you can still function in a classroom. Sometimes teachers get stressed out and they're not able to function in a classroom. This will prevent the employer from arbitrarily trying to get rid of you because of your injury or illness. So this obviously comes up quite a bit because teaching is a stressful job. So I have an asterisk here, but technically this would be code number 11. In the years of digging through the thousands and thousands of lines of codes, these are the only codes that are here to protect you. We're not talking about the labor code, obviously, right now. We're not talking about, your federal rights. We're just talking about strictly the Ed Code, which is overall a very hostile document. But good news is these codes will come in handy for you union organizers. Very handy. So hope this was helpful for you. I would put these aside. And if you have any questions, you can ask me. And hope this video was positive and can be helpful. This is Brian Crowell signing off.